Well, hello, everybody. This is another edition of Zoom Landlord-Tenant Talk Radio every Saturday at 3 p.m., regardless of how busy I am. I'm always going to make time for these meetings. It's been a busy week for me. I found myself in court on a case that I'm involved in, which I'm going to have some news to talk about that case, which will have an effect on landlords in general. I did want to talk about today. The initial topic will be something called Justice for Renters Act. Justice for Renters Act. Does anybody believe that land or tenants need more justice? Isn't everybody of the opinion that all laws are in favor of the tenants and the landlords have to jump through so many hoops to merely enforce their property rights? Well, it could get worse. And I'm going to start beating the drum on this particular issue as it gets closer. The Justice for Renters Act is an initiative that will be on the ballot. I think the person's name is Mitchell Weinstein. He's part of the AIDS Foundation. He has brought forth this initiative already 2 times. It has been defeated 2 times, and now he's bringing it forth again. So it qualifies and will be on the November ballot. So remember, it's called the Justice for Renters Act. And I don't think you got to be a physicist to figure out that when you see that, you better vote no. So what is this act supposed to do? Well, it allows local governments to impose strict rent control on single-family homes, townhouses, and condominiums. It also would allow local jurisdictions for new buildings to apply strict rent controls. So right now, if you have a townhouse, condominium, or a single family home, you can raise the rent to whatever you like, whenever you like. Now, it's easy for me to say that, and people are going to go, oh my God, they're just going to raise it to $10,000. But the reality is, this is something called the free market. It's the basis upon which our country was founded, a free market. And if I wanted to sell my car for $1 million, I would have the right to do so. But I can tell you that no one would buy it. And that's the way the economy works when you have a free economy. So allow the market to determine what the prices of things will be, have no governmental intrusion. And as we're on the subject, what other industry is issued with price controls? What other industry has price controls where the government has gone after that industry and says that you can't charge this? So let's go down the list of all those other industries. Oh, wait a second. There is no list because it's only landlords. But you have to understand, the argument would be made that housing is a critical factor for people and they need housing. Well, you know what else? People also need gasoline. There's no control over that. They need heating oil for their houses. They need to have baby formula, right? Is there any controls on any of these? Aren't those necessary things too? The only ones who they attack are the good guys. And we're housing providers. We perform a very valuable service for the people in not only the state of California, but across the nation. And we are the largest industry for of all industries. Some people think, oh, it's the agricultural industry, or it's the tech industry, or it's the motor vehicle industry. Well, if you don't believe me that income property owners and housing providers are the biggest industry, all you have to do is, wherever you are right now, step outside the front door and look to the left and look to the right. You will see housing providers, okay? And it doesn't matter where you are. So we are the largest industry, and we're under attack by our media, by our politicians. I was saying on another telecast that I had done just recently that what's the motivation for politicians to come after income property owners. And it's pretty simple. There's more tenants than landlords. And if they can curry favor, then they're going to believe, notwithstanding what's good for the country, what's good for people in general, they're going to vote so that they can get reelected. And by the way, who pays for rent control? If you've got a guy in one of your units that is grandfathered in with rent control and he's been there for 100 years and the rent is $642 for a two-bedroom, do you know who's really going to be subsidizing him? It's going to be the next tenant who moves into a two-bedroom. So if you have another two-bedroom unit in the property, you're going to have to make it up. So as we all know, rent control makes rents higher. They don't lower rent. They make rents higher. They also cut down on supply, because why would any investor in their right mind want to build apartment units in California where you're going to have so many rules and regulations and permits and delays before you finally get ready, and then you're going to be sandwiched with crazy politicians. So going back to this Justice for Renters Act, right now in the state of California, based on a wonderful law called Costa-Hawkins, which was enacted back in 1995, they cannot, no municipality cannot put limitations on a single family home, only one house on the lot, a condominium, or a townhouse, with some rare exceptions. You can raise the rent to whatever you like. And again, it's not whatever you like, it's what the market will bear. But Costa-Hawkins did one more thing, which is incredibly important and which would affect everybody here in the state of California. It said that there could be no vacancy decontrol. So in other words, when a tenant moved out and the unit is vacant, and now you have the right as the owner of the building to set whatever rent you want, which we all know still has to be market rent. Right now, they want to do away with vacancy decontrol. So, and that's what Costa-Hawkins guaranteed. And they're trying to get rid of this Costa-Hawkins Act, which means that when a tenant moves out, maybe they'll give you a 5% rent increase, a 10% rent increase. This will destroy the housing industry in the state of California. Not that it's not already destroyed. And as I've said on a previous broadcast, I personally will not invest any further in the state of California. I always had a rule that, you know what, whatever I do, I want to be able to be 20 minutes from the properties that I own. Well, throw that out the window. The last project I just did a couple of months ago is a major project in Las Vegas. So I'm heading out, of course, not my law practice, but I am heading out to out of this state for any kind of investments, because this state is truly and without question drinking Kool-Aid. So that's my sermon for the day. Tell all your friends, Justice for Renters Acts will only make anybody with a single family home, so it's not even really landlords, they'll put them under the gun. Right now in the city of Los Angeles, for example, if you have a single family home, and you want to sell it with a tenant in possession, you can't ask the tenant to move for the sole purpose that I'm selling, I want to get out. You have to have cause, and that's not one of the cause. So this is just an elongation of the new initiative coming up on the ballot in November, so we're not that far away. Oh, one more thing I wanted to say. We don't know where we're going with this. We really don't know. If you have a single family home that's leased, or a condo or a townhouse, right now, today, make sure that your rents are at market level. If they are not at market level, you need to serve a rent increase notice right now, today, to raise it, and maybe even a little bit more. If you're going to go above 10%, you have to serve a 90-day notice. 10% or less is a 30-day notice. Right now, if you serve a 90-day notice, make it effective as of May 1st. Whatever the market will bear is what you should be raising that rents to, because we don't know what's going to happen with this initiative. And it's absolutely insane what the politicians are doing. Right now, if you're going to serve a rent increase notice like the one for Los Angeles, which is a 4% for RSO properties, make it effective as of March 1st. We always have to give an extra 5 days for mailing. So it's a 90 plus 5 notice, or it's a 30 plus 5 notice. But be sure that you are raising your rents to market level, because if your rents are at market level, you cannot be hurt. But if your rents are not at market level, then when these laws pass, and it's just a matter of time, and hopefully it'll be defeated the third time, but when these laws pass, you're going to get stuck. You didn't raise your rent. The tenant was nice. I didn't feel like doing it. He didn't give me any trouble. You are killing yourself. Okay, so make sure every property that you own, if you can do a rent increase, do a rent increase for rent control properties, and for non-rent control properties, make sure that your rents are at market level. And with that, ladies and gentlemen, we're now going to move over to our callers. Let's see how I can pull this up. Bear with me. Participants. There we go. And let's put this over here for a change. You do know that this telecast, this Zoom meeting, is for informational purposes only. It is not a substitute for quality legal advice, even though I've been doing this for 47 years. So if you really truly need legal help, then please seek that out. Also, I will call on you once your hand is electronically raised, which you can see on the bottom of your screen in most situations where there'll be an icon that says raise your hand. Try to keep your questions short and to the point so that we can get everybody in. And right now we are going to call on Eric, who's been very patient. I'm going to ask you to unmute yourself. Can you hear me, Eric?
Yes, I do. Thank you. Thanks so much for doing this. You're very, very kind. Appreciate it. I have a couple of questions on your 3-day notice to pay rent or quit.
Okay.
I'll ask them rapid fire because I know you know the answers quick. Do I need to include John and Jane Doe's 1 through 10 like we used to do in the old days?
Well, if you look at that notice, it says right underneath the names, it says, and all others in possession. So you don't have to worry about that.
Thank you. What about a cosigner who does not live there?
A cosigner is not, I'm glad you raised that because it allows me to give a little bit of a speech here. A cosigner is not someone who's a tenant. He's a cosigner. He's guaranteeing the provisions of the lease. So you would never put a cosigner's name into a 3-day notice. A cosigner, and because after the 3-day notice, what do we file? We file something called an unlawful detainer. A cosigner is not unlawfully detaining the premises. So my theory on cosigners is as follows, and that is that I believe that the people who are living in your unit should have sufficient credit, and I would never take a cosigner.
We lost you there, Dennis.
Okay, let me try again. Can you hear me
lost your
now?
audio.
My audio? My audio sounds good to me. I think I'm good. Can you not hear me? Maybe it's you. Everybody else, raise your hand visually if you can hear me. Okay, good. So thank you. So I think it was you, young sir. But sure, throw me off. But so if the person who is moving into your unit doesn't have sufficient credit, I would not take a cosigner, okay? Now, sometimes you're dealing with situations where it's really difficult. Let's pretend you have student housing. You have your properties down by USC, and these people are students. So you want to get the parents responsible. Well, number one, don't make them a cosigner. Make them a tenant. This way you can include them in the 3-day notice. So forget the concept of a tenant. You don't have to live in a unit to be a tenant, okay? I could have 14 apartments and I never show up with one all across the United States, and yet my name's on that list. So what you want to do is make them a tenant. Now, if this quote cosigner, now we're calling him tenant, lives in Des Moines, then you're worthless. You're not going to go to Des Moines to sue these people, okay? So it's got to be somebody local. Do I want somebody in San Francisco? No. I want a tenant local here where it's easy to find where they are. So with generally speaking, if you're going to rent out a unit, make sure that the people who are going to be occupying the unit have sufficient credit, otherwise shy away with them. If you have some exigent circumstances why you kind of need a co-signer, don't call them a co-signer, call them a tenant, and we never get involved in that.
Thank you. Do I have to serve both tenants, or if I serve one, is that sufficient?
Technically speaking, you're supposed to walk over to the door, knock on the door. You have, if there's two tenants, you have two copies, and you put one in A's hand and you put one in B's hand. If only A opens the door, then you hand two to A and you mail one to B. Okay. And if nobody's home, then technically you're supposed to put two on the door and mail in separate envelopes, one to A and one to B.
And very quickly, is it okay for the address to pay? If they pay by Venmo normally, can I put my PO box or by Venmo with
You
my
can do
address?
you can do that as long as you're having Venmo is not a proper way to do it, but it's okay as an alternative way. So as long as you have your PO box, and of course your phone number and an individual's name. So if you have it in a company, you got to put an individual's name. Obviously, there's no times when you can send something to a PO box, but if you do have a physical address, you do have to put the times like 9 to 5, Monday through Saturday,
All
etc.
right.
on that. But there's nothing wrong with that. If you are going to do a bank account, which is kind of like Venmo, then you have to list the name of the bank. You have to list the hours that the bank is opened. And you have to have obviously your an address of the bank, which is in 5 miles of the subject property. So if you want to do a bank, or you can say, or Venmo, which is really the same thing, but you have to have a specific address under the code. Hopefully
Okay.
that answers all your questions, young sir.
I was wondering about proof of service. I don't see a proof of service on your 3-day notice. Do we still need proof of service in LA City?
You don't need a proof of service because once you start the eviction, that's when you're going to need it, and that's what we prepare for our clients.
Thank you very much. And then just one quick, just a constructive on your words at the end. At this time, we have not been informed a unit is in need of any repairs. You say we take out responsibility as a landlord very seriously instead of our. I think you have a typo.
I think I do, and I'm going to change that after the show. Thank you for pointing that out.
Thank you, sir. Thank you for doing this. Really appreciate it.
Eric, nice talking with you. We're going to move along. Next in line here is, let's go back to Dina, who has brand new questions to ask. Please unmute yourself.
Yeah, hi, Dennis. Thank you for doing this. And indeed, I have two very interesting questions. The first actually is about the, the new laws. And then when we make the lease agreement, we have to give notices and stuff in those laws. And I really appreciate your, lease agreement, but is it updated up to those laws, or when
Well,
it's going to be?
we're going to be making some changes on that this month. I've been kind of involved, as I told you, with a lawsuit that I'm personally in, and where I'm the plaintiff, I might add. And
Okay.
so, as opposed, if you have a choice between being a plaintiff and a defendant, let me tell you something. Much better to be a
Of
plaintiff,
course. Yeah.
most plaintiffs has to or do decide that they want to bring forth a lawsuit.
Right.
No tenant decides that, I think I want to get sued today. So it's much better. But yeah, we're going to be making some changes based on the new rules. But right now, most of those rules haven't come into effect. So the rental agreement is still valid.
Okay, so hopefully this month so we can use it right away.
Yes, darling.
Okay, and one more question, little bit interesting. I don't know if you have come across something. My tenant recently, he emailed me and he said, you know what, future rent payment, because he paid me by Zelle, which is on the lease agreement, future rent payment will be coming from a different bank account. So I emailed him back and I said, it's not clear to me if this, like, quote unquote different bank account belongs to you, because it has to be your bank account, your wife bank account, because both of them are on the lease. and or a joint account of both. Otherwise, you need to follow 1947.3. But he never replied back to me, and I don't know what to do now.
Okay, well, first of all, when you say bank account, is he transferring the money directly to your bank account?
He's transferring through Zelle by
Right, so it doesn't make any difference.
right,
That's not,
exactly.
regardless of whose account it's coming from, you didn't actively take a check and deposit it into your account. So it's not like you're accepting rent
Right.
from a
Except,
stranger's.
yeah,
Let, let,
except,
let, let me
yeah,
finish though.
sorry.
You're not accepting rent from a stranger in that situation. So it really doesn't matter. My thought is he told you that it's coming from a different bank because he wanted to make sure that you knew that, hey, this is me. Don't think you be confused as to who's sending you this money. That's what I think his thought process was.
But I didn't think this way, Dennis, because in Zelle, they don't tell you what bank account. They tell you the name sending you the money and the amount of money. However, my also concern, because there is something that if somebody else paid the rent, they have to declare and they say, I'm not renting, I'm not the capacity of a renter, I'm just paying the rent for those people. And then you have to authorize that as the landlord before they can proceed. And that's what scares me if he wants to hook up somebody, because he has been very much nagging since he broke the lease that I want to advertise the appointment. I have somebody to bring to rent the apartment. So this is where my fear is. Like,
Right.
if
But
he, yeah.
but again, unless you're physically depositing the money into your account, the fact that it's getting into your account is not considered any kind of a waiver on your part. So
Oh,
it's
even if
not,
it comes from a different subject?
it doesn't matter. You say if he authorized somebody to put something in your account, you have to have an advert act on your part where you're physically depositing the check by a stranger, and then you're responsible. Hey, money showed up in my account, and it's noted that it's from this person. That's it.
Oh, so it has to have his name, the tenant
But you
name.
already said that Zelle does show the name, so.
Yeah, because they are saying, even I called the bank, they are saying we don't control Zelle. And sometimes if somebody knows account of someone, they can send them money. And then at the end, it will, if they share their phone numbers and email with the renter, then that could come under their name too. And that's where I'm like, okay.
I wouldn't worry about it, but Dina, good question.
Okay,
And
thank you so much.
take care. She's our star. She comes in every week. But here's a man I talked to last week, who, in my opinion, needed to start a case immediately. So let's talk to Rick R. I'm going to ask you to unmute yourself. Rick R.
Yes. Can you hear
Hey
me,
there.
Dennis?
I can. How are you, sir?
All right. I'm good. Thank you. Yes. Uh, for those who weren't here, it's a single family house in unincorporated LA County. It's in the Antelope Valley. Um, I forgot to ask you, the tenants last August moved in two pit bulls. And of course, in the uh, rental agreement, the lease, which is now month to month, it says no animals without my permission, but it also says you have to pay rent too. So I mean, is that a factor? And can you base an eviction based on the two pit bulls?
Yes, or you can do it on the two pit bulls, and in your situation, the tenants also owe you rent. So we
Right.
could actually do it on both issues. However, for unincorporated area of LA County, you have to serve a 10-day notice to perform or quit to get rid of the animals. So you would have to then, if you wanted to do it concurrently, you'd have to change a 3-day notice to pay rent into a 10-day notice. So, but in your situation, for the audience, you talked last week, and the tenant owes you a bunch of money,
He does.
and you're attempting to talk him out and coddle him and massage his feet. I don't know what you're doing with him, but
Well, there's been a new development.
oh, sure, tell me.
What you said was that do you want to adopt your tenant? And I said, well, no, that was kind of a wake-up call. The new development is I have a property manager. Well, I was trying to get this tenant before I talked to you to join the LA County Rent Relief Program, which basically is for landlords. Um, I'm not sure that he did that, which I'm hoping he kind of didn't. Even though they're open 7 days a week, they're closed today, I guess for 3 days for MLK. So I can find out Tuesday about that. But they came in and they paid the property manager a month and a half's rent, and the property manager took it,
And
saying
so,
that would be for September. Now, a partial payment for October, so I don't know if
well,
you can count
well,
October.
it doesn't matter because we can go back we can go back to at least April without any issues. So from April to January, what you do is add up how many months that is, which I believe it's now 10 months, subtract all the payments they made for that 10-month period, and that's the figure you're going to put into a 3-day notice to pay rent or quit. But
Well,
waiting for,
yeah, I'm sorry. It's not that much now because they got from the I forget the name of the program.
the California Rent Relief Act.
Rent, yeah, it's preventative eviction defense fund. That's what it
Yeah.
was. They got paid through August on that.
Okay, but right now, how much rent do they owe you?
Well, if they didn't get in the program, they owe me
Well,
half of October, November, December, and now January.
okay,
So
so they owe you
three
three
and
and
a
a half
half.
months.
Yes,
Okay, and the rent per month is $2,000 as memory serves me.
your good memory.
So that's $7,000.
Hmm.
My good friend, I'm going to say the same thing again.
Right.
And don't forget, maybe I should have said it to you in this fashion. When you start an eviction case, you're not taking the tenant and throwing them over the cliff. An eviction case is going to take 2.5 months, and with the sheriff being so slow, maybe 3 months. Is it possible that during that 2.5 month period, 3 month period, that the tenant gets the money, you accept it, he pays your attorney's fees, and he gets to stay? So it's not like once you start the eviction, you have no choice. Cases get settled all the time where hopefully the tenant will pay the attorney's fees as well and also
Well,
pay.
hopefully, but he had last time when we went to court for the eviction defense fund, he had tenant, he had lawyer representation for free, and also he wanted to do a jury trial, and he had a jury trial lawyer that was supposed to do it for free.
Right.
So he's not he's it's a bit of a sticky case, but it's
Right. But
uh
again, we'll go back to that adoption.
yeah,
If
I
you
don't want
don't
to
do
do that.
anything, then that means you just adopted him as your son. And just like when my kids were going to school, they didn't have to pay any rent because I took care of it for them. So
Right. Do you on LA County unincorporated up would you go to Lancaster Court or would you go to downtown LA?
that's probably Lancaster. You don't have a choice where you go to.
Oh, okay.
It's
It'd be
all decided
Lancaster
by the
then.
court. It probably would definitely be the Lancaster court, but you don't really have a choice
Yeah,
of
that's
which
where we
court.
went before. I thought maybe you had a choice.
No, they don't. If they did, I'd have it in the closest court to my office to make it easy for me, but that's not the
Right.
way it is. Anyway, Rick, good luck. I hope
Yes, thank
you
you.
make a decision one day.
Yes, I'll be calling you. I will.
Okay, it's okay, but I'm looking out for you, honestly. We
Thank you.
have tons of cases, but I am looking out for you.
Thank
Take
you.
care, sir.
And
Okay, so we're gonna lower Rick's hand. And in order of how I'm seeing him here, I've got a young lady by the name of Mia. Mia, I'm gonna ask you to unmute yourself. Mia, how are you? There you are.
Hi,
Hi,
Mr. Block. Can you hear me?
I can.
Hi, Mr. Dennis. Can you hear me?
I can, but you might want to
Hi.
adjust your camera.
I have a single 2 bedroom home.
There you go.
Oh,
Now I
okay.
can.
I'm sorry. I have a 2 bedroom single family home in Los Angeles City. Can you
Okay.
hear me?
I hear you wonderfully. Go ahead.
Hello. Oh,
Uh,
okay. Okay. And I have tenants that's been staying in our property for 2 years and haven't paid any rent. and I just started an unlawful detainer in December. My question is, he owes over $24,000 worth of rent. And my question to you today is, do the tenant have to post all the money to ask for a jury trial because he got those free lawyers that help with eviction? And he said he's going to ask for a jury trial. So my question is, if he asks for a jury trial, do we have to post all the money before he can get a jury trial? Because he still doesn't want to we're suing for possession of the property. I already got 3 judgments against him for all my back rent. And I just want to know, do he have to post all the money for him to have a jury trial? Because he still refuses to pay any of the rent, and he still refuses to.
Mia, let me answer the question, darling. Okay. First of all, jury fees have to be posted for each day. Jury fees are $150 per day. However, all tenants get something called a fee waiver. They file a paper with the court saying they don't have any money, and they don't even pay the initial filing fee that the landlord pays. And it's shocking to me that every single tenant, even a person we were evicting who was renting a $50,000 home in Brentwood, got a fee waiver. The judges just sign off on these. So he can ask for a jury trial. He'll have a fee waiver. He doesn't have to pay the $150 per month. Is there a follow-up question, young lady? Well, I think you're having trouble with your audio. And by the way, everybody, as we can see, a little tip on videography is always have the light in front of you, not behind you. Okay, but anyway, thank you very much, Mia. And we're going to move along. And let's move over to... Oh, sorry, Mia.
Okay.
Let's move on to,
okay.
Let's see, bear with me. Yes, she should be muted. Okay, let's move on to a cell phone. For cell phones, when I call on you, you're going to hit *6 to unmute yourself, *6. And I'm going to call on the cell phone that is 4379. It ends with 4379. I'm going to ask you to unmute yourself. Hello, 4379. Yeah, 4379. It says that you're unmuted. Can you say hello? *6. *6. Are you there?
Hi, Dennis. How are you? Yes,
I'm here. Fine, thank you.
Yes, Dennis, I have another question. I spoke with you last week about an eviction case that litigated for nearly a year, and we lost on a technicality.
Yes.
My attorney has now hit me with a new bombshell, and I think I'm going to have to let her go. What she's telling me now is we gave a new 3-day notice, and I think it was in December, for rent that was due from April of 2023 through December of 2023. But she's telling me something about the defendant filed something called a demurre, whatever that is. And in that demurre is stating that for the period of time that we're asking for rent, there was no lease in effect during that time. The lease was terminated. I'm not sure what that has to do with anything. Could you give me any information on that?
I can share some light on that. A demurre is that when you've been served with a lawsuit, you can either answer the lawsuit or you can file a demurre. There's other things you can do, but those are the 2 big ones. And a demurre basically is telling the court that, hey, this lawsuit makes no sense or it's totally illogical. Let's pretend you had a 3-day notice and you didn't have the right words in it. Somebody could file a demurre saying, I don't have to answer this because just take a look at the lawsuit and it's going to clearly show that this is a defective lawsuit. Now, based on the reason that they're talking about, they're out of their minds. So that lawsuit could not be bad for that reason that, quote, the lease was terminated. If the lease was terminated, why the hell are you still there? So that line, assuming you're saying the correct language of the demurre, that line means nothing. Many tenants filed demurres. even though they have no legal right to do so. They'll file it. And the reason why they file it is because they get a delay of the proceedings, because the longer they stay there, the longer they get to steal from you. So people will file demurs and they'll set the hearing date up for, let's pretend, February 28th. They'll set a hearing date for February 28th. And you can either sit and wait till February 28th, or what my firm does, we file an ex parte motion. That's like an emergency motion saying, hey, we don't want to wait till February 28th. This is a baseless demur. I want to have it heard next Tuesday. And then invariably the court will allow us to move it up. Then the court will state that the demur was not well taken. They'll overrule the demur and then order the tenant to answer within 5 days if he chooses to do so.
Okay, so she's also saying that there's two other things. There's another thing that in the prior lawsuit, that in the original lawsuit that we filed more than a year ago, there was two tenants on the lease, but during that time, my lawyer advised me to just only add one tenant on the lawsuit. We did that. We lost that case, so we filed this new lawsuit, and then we added both tenants. Is that the proper way when the other tenant don't even live in California? They live out of state?
I would never sue a person in an unlawful detainer who's not on the property. Number one, you can't serve them. How are you going to serve them? You're going to go take the paperwork to Arizona and try to find them over there. So you only want to sue those people who signed the rental agreement and or who paid the rent and who is occupying the premises. Remember, what you're filing is an unlawful detainer. You're declaring to the world that that person is unlawfully detaining the premises. So on that basis, I would only sue the people who are in possession.
I think we're in trouble because she got an email from that co-tenant before we even filed the lawsuit, and that co-tenant told her that she did not occupy the residence. She had nothing else to do with it, my lawyer still sued.
Let me get a word in. That doesn't mean that tenant who signed the rental agreement is not responsible for the rent. If they signed a rental agreement, they are. They're just not guilty of being an unlawful detainer. So I would just recommend, without looking at anything further, that your attorney just file a dismissal as to that defendant only. No big deal. Takes 1 second.
Okay. And the last question is that she did brought up something. I don't know if this is a small issue, but on the 3-day notice where it shows, because I have a property manager, and when she did the 3-day notice, where to pay rent to?
I am sorry, but you're breaking up. I could not hear that last question.
Okay, I'm sorry. Can you hear me?
I can now, but go ahead.
Yes. On the 3-day notice, when my property manager did the 3-day notice, she put everything correct. Where to pay the rent at. The address is correct, but not the zip code. Is that a problem, or could we just keep going with it being that way?
If you have the wrong zip code and you're going to get involved in potentially another jury trial, whatever, you want to start this case over again. If it's got the wrong zip code, where to pay the rent, unless is the place right by, where is the apartment right by the address where the rent is to be paid?
Yes, it's in the same building because I have where the property manager
Then
goes.
I don't think that's a big deal. If you're telling him to pay it to the same building, I don't know. It's a close call. You could get some judges that say the notice is defective. So it's really unfortunate that they have the wrong zip code, but you might want to start that case over. All right, I'm going to move on.
Thank you so much.
Thank you, sir. And let's lower your hand. Let's move over to Riley. Mr. Riley, I presume if you would unmute yourself.
Yes, hi. I'm in the process of trying to find a good eviction lawyer. I've been doing like a lot of research online and stuff and feedback. And I see you do have a lot of negative feedback. Could you explain why is that? I mean, why does...
Well, part of the lawsuit that I'm involved in deals with phony people who have put that on. I have a lot of tenants that put that on. But I've been in business for 47 years, Riley. And in 47 years, you're not going to make everybody happy, but we have legions of clients. And if you go to my reviews on my website, one after another, that shows how many people like it. And just the fact that of this forum that I'm not getting paid for this, we donate our time. In fact, if you call our office, we take in so many phone calls, but over half the phone calls are just landlords who are calling up who are either our client or you're not our client, and we're sitting there and answering questions at absolutely no charge. I'm sure many people in this room have called my office and have gotten their answers to questions at no charge. So I think my firm is second to none in going forward with landlord-tenant issues. Of course, you're not going to make everybody happy, and I don't try to make everybody happy, but I'll tell you what I do. I do try to win every case that we're involved in, and I give it my all. There is no one who works as hard as I do, certainly in this field. I'm at the office at 5:30 in the morning, answering questions even at that early time period, and our trial attorneys are incredible. We've won our last 5 jury trials in a row, one of them against a notable firm by the name of Basta, which people might have heard of. But we're really excellent in what we do, and the rules and obligations that the politicians have put to us, where it's constantly changing. We filed lawsuits where the law was one way, and in the middle of the lawsuit they changed it. So things can happen in these cases, but there's no one who has been working harder for landlords in this area of law than the person who you're looking at. But anyway, thank you very much, Riley. I'm going to move on. Let's move on to another cell phone. It is ends in 3726. I'm going to ask you to unmute yourself by doing *6.
Hi, it's Suzette, Dennis. How are you?
Suzette, how are you?
I'm good. Okay, I was in the Zoom meeting. You had like 29 people over there, but we couldn't see you or hear you, so I had to call. We could see each other, but we couldn't see you in the Zoom meeting. So I just hung up. I got out of there and I called. I missed.
Yeah, I don't know why, because some people are getting through without any problems. Obviously, we have 20 now. And by the way, we're also on YouTube Live. So, and a lot of people are a little gun shy to be in the meetings. I wished everybody was in the meetings, and I wished everybody let their camera open, because it makes it for a better situation. And I try to call on the people whose cameras are open, but in the YouTube Live right now, there's about 50 people in there. And then the people who are watching it as the video that we do after the show, we have over 500 people per week that are tuning in to this forum. So we're trying to spread the word out there. But anyway, what's your question, Suzette?
I have 2 questions. The first question is, if a tenant says that they're going to try to get like these programs to assist, do we have to accept that?
No, you do not. There is no obligation to accept the rent subsidies from these outside sources.
Okay. And then also, can I evict if the tenant, so they're storing things in the garage, and I told them that they don't have storage is not included in the rent. They have one side of the garage, but they're occupying the other side with their junk. So can I evict based on that?
Well, it depends the terms of the rental agreement. If that's in violation of the rental agreement, then certainly we could make a demand for them to remove those items. And if they don't, then we could evict.
Okay, yeah. Thank you.
All right, darling. Thank you for calling. All right, let's move on to, let's see here. Let's move on to Kurt Fremont. Kurt Fremont, unmute yourself, young sir.
There we go. Hi, Dennis. Again, thank you for taking the call. I want to tell everyone the workaround. I had the same situation. I came into the meeting. There were 29 people here, but not the wonderful Dennis Block. And so I logged out of the link, and then I put in the code and the passcode, and that's how I got in. So that was my workaround. So
just curious, did it show at least my name, or it just showed nothing?
No, sir. When you click the link in your Evict 123, that's what I did first. 29 people were there, but you were not there. And I go, and I was the first one to say, let me see YouTube Live to see if the meeting's taking place. And when it did, I go, let me think of a workaround. I know you had a thing where the meeting ID and the passcode. So then I went in that way and I got in. So
yeah, I think I'm going to have to renew that. I keep using the same meeting code and passcode, and I don't know, maybe Zoom's having a little bit of problems with it, but so I'll edit that for next time. But
no
I'm
worries.
glad you made the challenge to get through.
Did it. So I thank you for having the meeting. I really appreciate your time. A couple of quick questions. I have an RSO triplex unit and I pay for the water. As you know, when you go into tier 2 with the Department of Water and Power, tier 2 water becomes more expensive. I'm assuming there's nothing I can do but pass on tier 2 cost to tenants if it's not in their lease, correct?
What city is this again?
Los Angeles RSO.
Well, you can't pass on anything if they weren't supposed to pay for the water. So
okay.
There's nothing that you can pass on. All you can do is do your whopping 4% rent increase.
Okay. So then my second question, if I decide to take any unit and put a separate water meter into that unit, I know that the rent is reduced by a percentage. Do you know what the percentage is?
Okay, what you're talking about, assuming you went to that, you'd have to just give a decrease in the rent to the same amount every month that the water bill was. So it doesn't make any sense. It would make sense for new tenants coming in that you could put in either the rubs that they call that, ratio utility bills, where they have just a formula for determining how much each unit is using. And that can be put into a brand new rental agreement for a new tenant coming in, but not for existing tenants.
Okay, but just hypothetically, if I did do a separate water meter to a particular tenant, can I file a capital improvement charge with the city and make the tenant pay half the cost of that water meter?
I don't think so. I don't think that's really can be considered a capital improvement where you're trying to get the tenant to pay the water bill. Capital improvements, deal with like heating systems and roof or the retrofit, that kind of stuff.
Okay. All righty. Thank you very much for your time. I appreciate it.
Thank you. I'll try to have that worked out by next week. Always something new on these things. I've had a big education with it. All right. Now we are going to move on to Jay Law. Jay Law, please unmute yourself. If Jay Law is there, you go.
Yes, Dennis.
Hello.
Sorry about that. Hey, quick question. Two quick questions. One, I had a tenant who moved out after being behind on rent. I suggested that he just move on out instead of me having to evict him since he was a young guy. What is the process for me? I think you guys offer this service, but I'd like to figure out what is the process for me to recoup those 3 months of rent.
The best way and the cheapest way would be just assume in small claims court. It's going to cost you $50, $60. They don't allow attorneys in small claims court, and it's the best way to get a judgment against him and then see if he'll pay. If he won't, then of course, a firm like myself, we do collections at our firm as well because we collect on the judgments we get. We could assist you with that, but you got to file your own your own small claims court lawsuit.
What if I can't find this guy? I don't have an address for him other than what's on his driver's license. Do I just use that?
Do you know where he works?
Nope. That's part of the problem. He lost his job.
When did he move out?
He moved out last July.
July. So it's been over 6 months.
Yeah. Didn't we have to wait a little bit until the pandemic relief?
Well, what months did he owe you for?
I'd have to go back and look, to be honest.
Okay. I'll tell you what, I'm going to make you a special deal. And here's the special deal. You can't sue somebody you can sue anybody in small claims court, but you got to serve it. And if you don't know where they are, how do you find out where they are? So you have to do something called skip tracing. So since you are a loyal member of the Zoom Landlord-Tenant Talk Radio, if you call my office, I'm going to just need to have I just need to know the address where he moved from. Give me the address where he's moved from and then where he moved from your building. And generally in 6 months, I can determine that where he's established a new residence, because normally you're going to establish credit at that new residence, and we can do it from his credit.
Okay.
So just
All
call
right.
the office and say, I want to talk to Dennis, and I was his Zoom guest, and we'll do it at no charge for you.
I appreciate that. And then last question. I have another building. One of the units has not been remodeled at all. The guy is kind of a little bit on the slum side of things. He's a low-paying tenant as well. I'd really like to move him to an adjacent unit in the same building so that I can remodel it and increase the market rent. Is that something I can do?
What city?
It's in Westchester.
Okay, so Westchester is the city of Los Angeles. They don't allow you to evict the tenant to do renovation. I'm assuming it's under RSO, correct?
Yes.
Okay, so that you can't say, I'm going to do renovation, you got to get out. If you weren't under RSO, you could do it. But since you are, RSO, everybody stands for the Rent Stabilization Ordinance. It deals with multifamily buildings or a duplex that were built prior to October 1st, 1978. So you can't do that. But you could say, hey, I'll let you move to this other unit. You can charge whatever you want. I'll give you a discount on this other unit. And it's a nice looking unit if you decide to voluntarily move out of this unit to the other unit. If you can get him to bite on that, then once he moves out, you'll still get a little bit more rent from him for the other unit. And now you'll be able to fix up this other unit, renovate it, and make a bunch of money.
Okay, sounds good. Thank you. I'll call you guys on Tuesday.
Hey, take care. Oh, actually, you know what? Let it be known. I told you I work hard. We're open on Monday. And I'll have all the attorneys there. Every time we have like a court-free day, I call a meeting with all the attorneys and I serve bagels. So if you're in the neighborhood, come by, I'll give you a bagel. All right, everybody, let's move on to, let's see, I don't see anybody who has got a camera open. So I'm going to move on to iPad 55. I'm going to ask you to unmute yourself. iPad 55. Unmute yourself, please. One more chance. Okay, I don't think you are. So on that basis, I'm going to move to Novastar. Novastar, if you could unmute yourself, please.
Yeah, hi, can you hear me?
I can.
Okay, thank you very much for taking my call. The question is regarding Ellis Act. So I have a couple of tenants, and we served them in April of last year. As soon as it opened up, that we're taking the units of the market. So the city assessed the relocation fees. One was qualified, one was not qualified. So basically, then they asked for extension, which I granted because there was no point in kicking one out when the second was qualified. So a couple of days ago, they basically informed me no matter what I do, and I constantly, even right now, put in complaints for non-existent repairs, what have you. But the question is, if Delray told us they're not moving out under any circumstances. So the question is, if I have to hire you, for example, and sustain legal fees, do I still required to pay them the relocation fees if we win a case?
Yes. First of all, when you serve the notice, and when you serve the notice, it's a 120-day notice, but they just raised it to 180-day notice. For everybody listening, so that they don't get confused, he is trying to evict the tenant based on the Ellis Act. The Ellis Act deals with the concept that you're permanently removing the units from rental housing use. In most situations, you're going to demolish that triplex and you're going to build, about 16 units or whatever. So that's the concept of that. You also could just say, hey, I don't want to be a landlord anymore. So I have 5 units here. They're all going to be vacant. And I'm not demolishing, but I'm not going to rent them out. They have to be vacant for 10 years. And then you're allowed to release the premises at market value. But in most situations, it's developers such as you, sir, that are going to be doing something different, and those units won't exist anymore. when you serve that notice to terminate, which is either 120 days or 180 days, you still have to give the relocation within 15 days of the service of the notice, or set up an escrow account within 15 days.
Which we did.
So whether they move out or on time or not, they're still entitled to the money. If you have to go through an eviction case, they're still entitled to the money.
You got to be joking. So there is
I
no
never
downside.
joke about my work, and you never can joke about the evilness of the city council for Los Angeles.
So there is no downside for them whatsoever to file
Well,
just to
you
stay
can
around.
obviously be suing them for the rent for the time that they didn't get out. You can sue them for attorney's fees depending on the terminology in your rental agreement.
So, but again, if they're gonna lose unlawful detainer and we evict them through the courts, I still have to pay them relocation fees, which is like $22,500 in one case and 12.5 in another case.
And the answer is yes. Whether they comply with the notice or not, they're entitled to the money.
Wow. Unbelievable.
I would say you're right. It is unbelievable. I'm going to move on. I see somebody there. I'm going to ask Saul to unmute yourself. Saul Dahadol.
Yes, how are you, Dennis?
I am fine. Let's see your picture, young sir. Don't be shy.
All right, no problem.
There you
Okay.
go. I always like to look and see what's behind you, you know? So I see that printer there behind you, and this is obviously your home office.
Yeah, that's it. That's where I work, my regular job.
And who gets the other desk? Your wife?
Yeah. Well, when she decides to work, she can sit there.
Okay, well, hopefully she's not listening. Otherwise, you're probably not going to get dinner tonight.
Yeah, well, I'll make sure she's not watching YouTube either.
There you go.
Yeah, so my question is in regards to a tenant, LA City RSO. He's very disruptive with his music. Loud all the time. The tenants are complaining. The question is, how do I build a case to remove this tenant, especially LA City RSO?
Well, I mean, a nuisance is a nuisance. So the issue is, does this excessive level of music occur once every 4 months, once every 3 months, once a week? What is the consistency of this?
Almost all the time.
Okay, so how many units in the property?
There are 6.
Of the other 5 units, how many are complaining?
2 are consistently complaining. The other are kind of appeased. He has a peace to them. He has made peace with those people, and they kind of get along and drink together or things like that. But the other 2, one very 78-year-old lady, and the other lady works night shifts, so she needs her peace.
So I think we learned a valuable lesson. If you are going to be a noisy tenant, if you are, make sure you have a bunch of alcohol and invite everybody over.
Exactly. That's what he does.
In any event, that's a good case for eviction, but you need cooperation from those 2 people. If you get me 2 people who come into court and say, I am truly disturbed and bothered by this excessive music. Obviously, you've warned this guy a few times. He chooses not to listen to you. And that's a case that we can do in any jurisdiction, as long as you can get some tenants to come to court to say, hey, my life is miserable with this person.
Okay, gotcha. So one of the tenants already said that she would be willing to, the 78-year-old. So I can try to get the other one as well.
Yep.
So
Yes.
I served a 3-day notice a while back. How good is the 3-day notice for once you serve it? I mean, do you reserve it after a while?
Are we talking about a notice to quit based on the nuisance?
Yes.
Yeah, you're not going to have sufficient legal knowledge based on the way the law is to prepare one of those. Barely right now, people can't even serve a 3-day notice to pay the rent now, based on all the other forms that have to go to the city and based on those forms that need to be posted on the property, which would be a defect to the case. So certainly with a nuisance case, you do not want to do that. Make sure that you have dates for when these episodes occur. So go back and logs and say, hey, you did it on this date, you did it on this date, you did it on that date. so that we have a good reference. And these dates we actually have to even put into the notice. Okay.
Yeah. Okay.
All right. Thank you very much,
I
Saul.
asked the tenant
Appreciate you
to keep a
coming.
log. Thank you.
All right. Okay, let's see. I like to pick on people who I can see. So I see Susan. Let me see if I can find where you are here. Oh, there you are. I'm going to ask you to unmute yourself.
Okay. Hi, Dennis.
Hey, how are you?
I'm doing really good, thank you. Your office and you have helped me many times for my properties that I have. So thank you very, very much. I'm actually also a tenant. And so I have a question from the standpoint of a tenant, if it's okay if I ask.
It certainly is okay, but generally the answer should be the same, right?
Well, I don't know either way, whether I'm calling you as a landlord or calling you as the
Yeah,
tenant.
the answer
I
should
have a
really be the
question.
same.
It's a question about the law, right? So where I live, there's a spot, there's amenities. You know, there's a sign on in the front. I've actually lived here for 10 years and I use amenities. The spa has not been in operational order for a long time. And I've been emailing them about it and they just keep making empty promises, delay. It's been about two years that I've been emailing maybe 3 or 4 times a year. So I saw your question answer on a couple AOAs a little bit back ago about somebody who had a parking space, an amenity that no longer exists, and you had to address that saying that then there needs to be a reduction in rent. So I wanted to ask you about the spa. And I saw on the LAHD website, they have values for these different items. Now, I'm not in an RSO building, but I'm trying to get an idea of how much is the value of this.
Oh, you didn't say that. You're not in an RSO building?
Right.
That's interesting. It's much easier if you were in an RSO building.
I know.
So your building was built after 1979.
Correct.
Okay, so you're under what they call the Just Cause Ordinance. And for those you're basically under statewide rent control where you can do an 8.8% rent increase. I would still make a complaint to the LA Housing Department, and they might tell the landlord either fix it or or her rent's going to go down.
They told me that I'm not RSO.
All properties now are under what either RSO or JCO, the Just Cause Ordinance. I would say that you can probably. I don't want to advise you to tell them I'm going to take $25 off the rent on this one. Did they just recently raise your rent 8.8%?
They did, and I found 2 laws. I found one which was Civil Code 1942.4 based on a California Health Code 17920.3, where there's like 4 premises to it. And one is that when there is, one other aspect to it is the Department of Public Health has come out 4 times now, because not only is it not working, but the water went from brown to green to black with mosquitoes, and the vector control came out.
I have an idea. I got the idea. You ready?
I'm ready.
Okay. On that chart from the reduction of services in Los Angeles, how much did they say? Like $50, 35? What did they say?
It went up to 78. I think the lowest was 28, and it was from 2019. And this property is in Encino.
Okay, so what I would do, and how long have you been without it?
It never really was in working condition, but they were putting in a new heater. They put in an announcement 2 years ago that they're putting in a new heater, and then I asked,
why don't you go to small claims court?
Yes. Okay.
This is the easiest way, because you're not putting yourself in jeopardy by not paying the rent or reducing your rent. Go to small claims court and say, Your Honor, I would like to have a recap of the fees I've been paying for this, which included a jacuzzi. There is no jacuzzi. I've been writing them all these letters, and now I'm going to file a lawsuit. Now, you don't have to worry about retaliation, because in Los Angeles, they now have the Just Cause Ordinance. So they can't say, oh, you did this and I'm just going to serve you with a notice to quit because you're not under rent control. You are under the auspices of the Los Angeles, not that I'm in favor of this law, by the way.
I know. If I had to vote for the landlord versus the tenant, I'd vote for the landlord, but I'm getting some of the benefits.
Well, and everybody does, you know. I mean, I took PPP money because I had to basically tell all my attorneys during the pandemic that you can't work. So we had to take that money. If I had my druthers, I just would have said, keep the state open.
Yeah.
And I don't want your damn government money.
Right.
But it is what it is. So we all take advantage of when we have to. But I would think that's a much better approach. You might want to send them a letter saying intent to sue and saying, this is your last chance. Fix it or I'm going to be suing you for X amount of dollars. And I think that might get their attention. Or if not, you should be getting a lessened amount of rent due to the fact that they're not giving you an amenity that they had.
Okay, so with that said, that's exactly what I'm going to do. And with that said, first of all, how much do you think I should value?
Well, you said from 29 to 78, go in the middle, yes. $250.
Okay.
So what is that? That's going to be 600. You'll sue for $1,200.
For the last 2 years, you mean?
Yeah. Why not?
Yeah. And plus every rent.
And show them all your emails when you go into court.
Yes.
Okay, we are at the end. It's 4:06. I went much longer than I should. However, I'm still going to take one more call. Let's try that iPad again because I feel bad that they weren't on it. So,
hello.
Hi, iPad 55.
Hi, Dan. I'm sorry I can't get my video on, but my name is Mindy. And it's my mother's home. It's a single family home in Encino. So it's city of Los Angeles. These tenants haven't paid for 2 years and 1 month. They applied for the COVID rent relief. Housing is key.
Yes.
But we didn't know that we had to do an application. But regardless, I got the case ID numbers through emails that the tenant sent us. And one of the emails said, this is why I got the check and you didn't get the check, why the check was made out to me. But they signed under penalty of perjury that within 15 days
that they were going to give
they have to pay the landlord the money. So they never did.
Well, I would go sue them in small claims court because that's fraud. I mean, that's what we saw a lot of. You're not the first one to tell me this story where the rent relief money came. And because they didn't have the landlord's information, they sent it to the tenant. You might as well be throwing it out the window, your car window on the freeway, because there's no chance that a tenant's going to come and get it for you. So I would sue them for that. And but you're telling me also they haven't paid rent in 2 years. You need to start a lawsuit right now based on non-payment of rent.
So Dennis, we do have a lawsuit going. As soon as the eviction moratorium was over on March 31st, in June, we served them with a 3-day notice to quit or pay April and May. They haven't paid a penny. Then he filed a demurre, I heard you talk about earlier, to delay the case. They lost the demurre because they said there wasn't a lease. Oh, they didn't, that attorney fees shouldn't be paid, something like that. They lost that. We won that. Now he filed for habitability. Well, if the house is not habitable.
Okay, we mean in other words, he filed an answer, and in the answer, he claims that the premises are uninhabitable.
Uninhabitable, but under like where they're supposed to put details, he put absolutely nothing.
So, well, you just got to prosecute this case as fast as you can and get it to trial. So if he's filed an answer now, then you can now file something called a request for trial, and you should be in court in about 21 to 30 days.
So now the attorneys are doing a motion for summary judgment.
I think that's a good idea based on the fact that he didn't check anything. And that might be a way to quickly end your dilemma.
Okay. And I mean, is there any way to go after him for the money that the federal government he got? I mean, that's
yes, I think you can sue him for that. How much was the amount?
Well, it's $5,700 a month is the rent. And
you probably want to file a civil lawsuit against him because I don't know the small claims court, because basically he committed fraud. So yeah, that the money went to him. So I would file a regular civil lawsuit on that one. Anyway, I'm going to call it a day. We went actually a little bit longer than what I normally do. We did an hour and 10 minutes, but I think it was pretty good today. sorry if anybody had any problems getting in from that link. I'll see if I can update it, and I'll be here next week. And again, this will be posted on my YouTube channel. Just go to my website, evict123.com, and it'll link you over to the YouTube or even to the podcast. If you are on YouTube, I would consider it a personal favor if you guys could subscribe to my channel. It does help defray some of the cost of this. Not that I'm trying to earn any money, but it just defrays the cost of putting on these broadcasts. And once again, have a great weekend, everybody, and we'll see you next Saturday at 3 p.m.
Thank you.